to start, and then we'll get going right on time, so we keep on time.
Awesome. So hi, everybody. My name is Jessica Roerson, and I'm with the IBDS program in partnership with Sage Hill. And we're here today with Daniel Katesman from Colinaire, and he's going to walk us through some questions and answers that we prepared in advance of this session today. And Jenny, did you want to say hi?
I'll just say hi. I'm Jenny. I'm with the Sage Hill Community Futures Office. We're so honored to have Daniel here with us today, so we won't take up any more time. Do you have the treaty thing, Jessica?
You know what? I don't. And
okay, well, we'll get started. Yeah, okay. We'll go ahead with that. But no, with that, we'll let Daniel go start away.
Well, without much more ado then, thank you very much for having me today. I understand there's a few questions related to business corporations, and how to run a business. So I'll address as much of that as I can, but before I get into the meat and potatoes, just a bit of a background about who I am. I'm a lawyer at Colinaire, as Jessica mentioned. I was called to the bar in 2019, which means I've been practicing for a little over 2 years now. I was called in June, so about 2.5 years, I'd like to think. In my time at Colinaire, I've spent a lot of it as a generalist, meaning I practice in all areas. So if you've seen me before in another scope, that's just because I practice in all areas. I don't just specialize in necessarily one particular area. That being said, I have had some experience in corporate commercial law and business law, so this is not brand new to me by any means. However, what I'm going to be presenting on today is meant for informational purposes only. It's not to be relied upon as advice or sort of legal advice, more particularly. If you act on the information provided today as if it were and it doesn't work out, unfortunately, it's not provided for that purpose. It's provided only for informational purpose or reference material. If you need legal advice, it is my express opinion that you should contact a lawyer for that purpose, as every situation is unique and different. And for those reasons, general information is never applicable to this specific. So during today's presentation, if at any time you guys have any questions, please use the chat function. I'll stop myself and make sure I address those questions. I know there's a raise hand function as well, so I'll try and keep my eye out for that. But if I do miss anything, I know Jenny will keep me honest. So moving now into the first question I was provided, which is it difficult to move from a sole proprietorship to a legal corporation? The answer to that is it depends. And that's going to be my answer for pretty much every question today, because it's so fact specific. And yeah, unfortunately, those who have dealt with a lawyer before know that we love to say it depends. But in reality, that is a kind of part and parcel of the sphere and nature of things that we deal with, because as I said, if you're a sole proprietorship moving into a corporation that operates in a very limited capacity with one shareholder, but it's tax advantageous to you to go into a sole or a corporation, that's going to be fairly straightforward. However, if you're a sole proprietor and you've now taken on shareholders or prospective shareholders, and let's say there's 5 or 6 of you, that necessarily is a very complicated process, because you're going to need a universal shareholder agreement. You're going to need to involve a very specific type of accountant. You're going to need to get some good tax advice. You're going to need to get some good business advice. You're going to really have to be careful on how you structure things. So depending on what kind of business you're operating, it's also something to keep in consideration whether you want to move from a sole proprietorship to a partnership or a limited liability partnership or a corporation. Of course, all of these types of business operations have to do with what's called risk spreading, or risk, what I like to call risk avoidance, where, as I'm sure all of you know, if you operate within the sole proprietorship, it's not a requirement of the sole proprietorship to register that at ISC, Information Services Corp, because under the Business Act, that's not one of the types of or legal entities that need to be registered. So too with partnerships, you don't have to register them. You can. It's generally helpful if people are looking for you, but it's not a requirement as I understand it. Now, with a corporation, of course, you do have to register that at ISC, or else it is not legally binding. And the reason for that is, under the eyes of the law, a corporation is a person. It is a living, breathing person. And so I'll get into what that means in a bit here. But when I talk about risk avoidance, a corporation provides a significant amount of that. Now, with respect to a sole proprietorship, of course, you don't need to register that, but it is a risky business because it allows for anyone claiming against you to access your personal assets. It provides no protection to you personally. They can go right after you. So too with a straight up partnership, but of course, both your assets and your partner's assets are accessible. So it risk spreads a bit in that situation, depending on if you haven't drawn up a partnership agreement. Now, if you've drawn up a partnership agreement, you can, sort of risk spread that way, saying, well, one partner shall indemnify the other for all causes of action, whatever they may be. It's something that you could do, but not necessarily. And then, of course, a limited liability partnership is a specific legal entity, and you have to meet some requirements to be able to register under that. You'll find, like Culinary LLP, we're a limited liability partnership, but that's because we fit within those specific requirements. So again, that's something that you're going to want to talk to a business lawyer about if you're thinking of moving in one of those two directions, be it a sole proprietorship or a partnership. Lastly, when you talk about a corporation, as I mentioned, this is a living, breathing entity. It is separate and apart from the shareholders, which means if the corporation is sued, only the corporation is sued, not the shareholders. If you want to gain access to the shareholders, there's a very specific set of circumstances that allow you to do it. One of those specific set of circumstances would be fraud. If it's alleged that the shareholder has perpetrated a fraud on somebody, then you can what's called pierce the corporate veil. But it only happens in very specific sets of circumstances. And why a corporation is so attractive is because of that corporate veil. It sort of shuts off the shareholders from any liability that they could potentially face as a result of the business operation. It also, with a corporation, allows for a shareholder agreement to be drafted up, which will dictate how each shareholder is to act with one another. And the most effective portion of that could be a shotgun buy sell. So inside of a shareholder agreement, there can be a shotgun buy sell, which means that if one shareholder offers to the other a particular price for their shares, then that shareholder who is offered to either has to accept that or can turn around and buy out the other shareholders' assets for that amount. It essentially forces the hand over one or the other and avoids these long and protracted legal battles that sometimes occur as a result of an argument inside the corporation. I'm not saying it will work every time. Of course, there's litigation around this issue, but I'm saying that's something you definitely want to put in any shareholder agreement is a shotgun buy sell. The other thing you can do is structure how your shares are. You could have, say, 100 Class A preferred voting shares, 100 Class B non-voting preferred shares, 100 Class C non-voting non-preferred shares. What that means is you're allowed, you can tweak what the value of each share is worth. You can say if you don't want someone to have a voting privilege on any sort of particular issue that's before the corporation, you can give them non-voting shares. So that's, again, something that you're going to want to bring up with your lawyer in case you're bringing on, let's say, 3 or 4 shareholders, only 2 of which you want to have voting privileges. Again, because it's such a unique process moving from a sole proprietorship to a corporation, you're necessarily going to want to get some advice about what you want to do. The final piece of this is you got to make sure that it's financially responsible to move from a sole proprietorship to a corporation, because of course there are going to be tax implications for that. You want to make sure that you're making enough money, you're in the right sector, that you're not, taking on a whole bunch of costs by doing this. And what that necessarily means is you're going to have to meet with an accountant, not a lawyer. A lot of people think, well, since I'm moving to a sole proprietorship, from sole proprietorship to a corporation, a lawyer's involved, I don't need to worry about any accounting stuff. And that's not true. You always need an accountant involved. And in my opinion, especially with the business side of things, it's almost more important to have a good accountant than it is to have a good lawyer. If you have a really good accountant and an okay lawyer, as long as your accountant provides good instructions to the lawyer, you can get it done. But if you have a bad accountant and an okay lawyer, it's going to create some real problems. So you want to make sure you do your research and find someone that really knows their stuff about business and business corporations for this kind of, for a small business that's in its growth phase. as I assume when you move, you would be in your growth phase for your business. So in a nutshell, that's sort of whether or not it's difficult to move from a sole proprietorship to a legal corporation. And again, the answer is it depends. Next question is what business structure should I choose? Now that kind of touches upon the first question of, should I be a sole proprietorship, a partnership, or a corporation? It's a really difficult question to answer because without knowing the nature of the business, I really can't tell you whether it would be advantageous to be one type of business versus the other. I mean, we see a lot of partnerships come through the door because we'll draw up partnership agreements. So too will we see a lot of corporations come through the door because we're drafting up shareholder agreements, minutes, we're sending in resolutions, things like that. We don't see a lot of sole proprietorships come through the door because, of course, you don't need any foundational document to have a sole proprietorship. You just need to register a few things with the relevant legislative bodies, and you can have a business license and you can operate as a sole proprietorship. You don't really need much legal advice. In fact, I think there's quite a few resources online, not to mention Sage, that can help you probably do this. So the question is, what structure should I choose? That is so highly dependent on the business you're in, the size of your business. It would be impossible to say a one size fits all. But it really, if it's just you operating a business, sole proprietorship or a corporation would probably make the most sense. If it's you and a series of other owners or other operators, a partnership or a corporation would likely make the most sense. And again, it all depends on the nature of the business there. So what type of business structure should I choose? Rule of thumb might be how many operators there are. If there's just one or if there's multiple, and then get a lawyer involved to determine, whether or not you should go with the partnership route or the business corporation route. What contracts does my business need? Again, this is an extremely broad question, but I think a good one in terms of, if you're a service-based business, contracts are foundational. You always want to have a contract because in a service-based industry, litigation is synonymous. It's everywhere. So a lot of the times as a contractual interpretive tool, the courts go back to the time that the contract was drawn up and look at the intentions of the party as at the time of contract. And the way that they do that is by looking at the contract itself and what are the terms in the contract and what were the parties trying to achieve by signing this contract. So if I were to operate a house cleaning business and I had my client sign a contract, and in the contract I said that I would charge 60% interest. Well, obviously that is not going to fly in a court of law because 60% is ridiculously high. So you can't contract for things that are illegal. That's usury under the criminal code, and it's not going to work. But if you say, in the contract, I'm going to come to your house and clean your house 3 times a month, in the first week, the second week, and the fourth week of the month, then I only come the first and the second week, then we know, well, definitively you were supposed to come 3 weeks. You didn't come 3 weeks, you only came 2 weeks. You have damages there because you've paid for a service that you haven't received. But the alternative holds true. If I come the first week, second week, and fourth week as per my contract, but you only pay me for the first week and second week, I can then sue you for damages because you didn't pay me pursuant to the contract, right? And that thereby also what's really helpful with respect to contracts is it clarifies what each party means, because it's very easy under an oral contract to say, no, when we agreed it was going to be the first week, second week, and maybe the fourth week if we agreed to the fourth week being necessary. But I didn't tell you I wanted you on the fourth week, but you came anyway. That's on you. I got a free house cleaning. I'm not paying you for that. And it turns into a he said, she said, right? And now you've got this whole problem of how do I force this person who said they were going to pay me and now is not paying me? How do I get around that? And the answer is, well, standard form contract. And so what a standard form contract is it's a fillable contract. It's essentially the contract you use every single time, and you just fill in certain fields, right? So I'm always going to be the service provider. That's always going to be the same. My hourly rate, that's always going to be the same. Certain services I provide, such as vacuum cleaning or cleaning out lint traps or washing bathrooms, those are services I'm always going to provide. So that'll be in the service section of my contract. What's always going to change is when I'm coming to clean your house, who's the other side of the contract? So the house owner of the person that I'm cleaning. Other things could be, scope of services provided. You could provide, 15 different types of services, but then you define the scope within the contract. I'm only going to provide you 10 of the possible 15 services that I provide, and it's going to be agreed to in the contract. And that contract is your foundational document. That is what the relationship is based on. Now, just because it's foundational does not mean that's the end of the conversation. Of course, if you guys amend the contract by agreement at a later time, that's going to affect how both parties treat the contract. But like I say, it's always good to have that basic fallback provision. Now, the other question might be, if I'm always using the same contract every single time, does that mean that it's going to be interpreted the same every single time? You would think so, but no. Again, it really depends on how the parties interacted with one another. If during the time that the contract was in place, even though you guys agreed that I'd come the first, second, and fourth week, but during the time the contract was in operation, on multiple occasions, you would just email me after the second week and say, look, I really don't need you in that fourth week. Can you not come? And it was agreed, okay, I won't come that fourth week. There's a relationship in that, in the way that the contract was engaged in during the time it was in operation, that might force the court to say, well, although you guys agreed to 3 weeks, in reality, you only came, on an as needed basis. So we're going to interpret it that way. So like I said, it's a foundational document. It sets out what each party expected, but it doesn't by any means foreclose any chance of opening the contract up and looking at it sort of more logically. The other thing is, there's a legal rule that basically says, when it comes to two parties making a contract with one another, if there's any ambiguity in the contract, it's going to be interpreted against the party who wrote the contract. So what that means is, let's say in the contract, it says, I will come to your house 3 times a week or as needed, on an as needed basis. Well, that's an ambiguous term, because as needed to me is not going to be as needed to you. So if I say 3 times a month or as needed, that could mean 6 times a month to one person or 4 times maximum to another. And so what the contractual interpretive rule would be if the other side said, well, I read this term to mean it could be a potential of 6 times a month. Well, then the court's more than likely going to go that way with that contractual interpretive tool. Now, again, that's just a, off the top of my head example. There are plenty of examples out there, but that sort of gives you an idea of how careful you need to be in drafting your contracts, because a lot of business owners will think, well, I've been in the industry for a while. I've seen a lot of contracts. I may not be a lawyer, but I know what a contract should look like, and I'm pretty confident I can draft one myself. Of course, from just my own selfish point of view, I like to think lawyers, generally speaking, know what they're doing, and they provide that security for the business owner. But if you're going to go ahead and draft your own contract, you need to be aware that you're taking on a significant amount of liability when you do that. Now, the other thing is, when you draft those contracts, you want to make sure that you're not putting in anything that could sort of open yourself up to some sort of liability as well. And I mean, it's all well and good to have a contract that's mutually advantageous to both parties, but let's say you have in there a term that says, although I agree that my fees will be $25 an hour, I am open to negotiating what my effective rate will be. Well, that's a really uncomfortable term for me, because that opens up the possibility where you could, end up with a client who's only paying you $15 an hour and says, well, on Tuesday, November the 3rd, I talked to Jessica and she said, well, she was going to allow me to pay her $15 an hour, and I have a text message that I can't find, but that's what we agreed to, right? And per the contractual term, you've now kind of opened yourself up to that debate. So you want to make sure that you're not opening yourself up to those debates. So as I say, it's all well and good for you to sort of write down the terms that are most important to you within your contract, but I always would suggest bringing it to a lawyer to either review the contract and have that lawyer say, yeah, you know what, that's a pretty good idea. Or the lawyer might say, you know, that there's an issue there. The other thing that you might be aware of, especially in the growth phase of a business, is taking on expenses that you don't really need to take on. So if you retain a lawyer for general purposes, that retainer for a business might be between $5,000 and $10,000. That's a huge expenditure on the books for a business that's just starting out. What you might want to consider is using an unpacked service provider. So you're seeing it more and more in the legal sphere where lawyers will unpack their services. And what that means is a limited scope retainer. And what a limited scope retainer is for a lawyer is it's an agreement between the client and the lawyer in which both parties agree that the lawyer will only act on a very few specific terms. So let's say if Jessica were to come to me and say, well, I want to hire you on a limited scope retainer to only review and draft a general form contract for my new business. All I would be hired for would be that specific purpose. I'm not hired to communicate with any customers. I'm not hired to do any, other contract work or to provide any other service. I'm only for that siloed purpose. That's going to drive down the cost of retaining that lawyer. So it's potentially a reduction in fee from maybe a $5,000 general retainer to maybe only $1,000, $1,500 for that one contractual, basis. The other thing, again, building on how to use a contract, is if you build it into your practice that every single time for every single customer, you always get a signed contract, then there's an interpretive rule of the business efficacy rule, they call it in law. And it's if you have a procedure you follow every single time, it's a lot easier for you to sit up there on the stand and say, well, I can't really remember signing this particular contract, but I can tell you every single time I ever engage in any business, I always get this contract signed. And that carries a lot more weight than I think I signed it, but I'm not really sure what we agreed to, right? And if you always explain the material terms of the contract, such as the price, number of visits or service to be provided, again, if you can say every single time I do this, I can't remember if I did it in this particular instance, but it is my business practice to do this, again, that does help. So that comes back to getting that sort of legal advice to make sure that there's a set procedure that you do and that you make sure that you're presenting the proper contract. So what type of contract does my business need? Again, standard form contracts are generally very, very good for service-based industries. If it's a different type of industry, like if you're a distributor or something of that nature, those might need a little bit more work on the end, on your end, with your lawyer, because standard form for those are going to be a little bit more difficult to draft. And you're going to want to make sure, especially from a liability perspective, you've made the proper inquiries and considered all the possible liabilities you may incur. So looking at this from a specifically service-based perspective, standard form's great. If you're an intermediary or some other type of business corporation, I would suggest getting in touch with a lawyer and having a bit more of an in-depth conversation about what kind of business you're in. As a contractor, should I have a lawyer draft a contract template that is signed before the start of each job? So again, I think I've answered this question in the previous section. Standard form contracts are the way to go. From a legal perspective, what should we know about leasing commercial office spaces? Again, this comes down to contractual interpretation and making sure you understand what the document is you're signing. I mean, just from the very basic level of when you sign a commercial lease agreement, of course, you're agreeing to certain terms, and those terms are being that you're leasing a space for a certain point of time. You have rights to certain square footage. You might have access to certain fixtures depending on what they are. And then, of course, most importantly, are the default provisions. And what the default provisions are generally are what are acts of default that allow the leasing party to end the lease with the owning party to end the lease with the leasing party. And so you want to be very familiar with what those are, as well as use of the premises clauses. What particular use can the premises be put to? Because of course, if you go beyond that scope of the lease, then you enter into a sphere of, well, then, the owner of that property may not actually want that type of business operating, because it could be that that area of the city or wherever you're renting isn't zoned for that, right? So you want to make sure that you're not actually voiding the lease by engaging in activities that's specifically not contemplated within the lease. So from a legal perspective, what should you know about operating or signing a commercial lease is, it would be my recommendation, again, selfishly, always bring it to a lawyer after you've read it yourself, to have an intelligent conversation about, what are the acts of default, what are the use provisions, if there's any sort of, the default provisions, and if there's any sort of schedules or attachments to the lease, because that's how you can sort of run up against special exceptions within the lease. Because a lot of times in these commercial spheres, again, they use standard form contracts. It's a lot simpler for businesses to always use the same contract, but then tweak certain terms. So the schedules are always very, very important in those types of scheduling or those types of leasing arrangements, because generally those are the things that tweak the lease slightly to make it, effective as between the leasing party and the owning party. But again, it's so highly fact specific. There is no neat answer of, oh, this is the one clause you have to watch out for, because there just isn't one, in my opinion. But of course, the most important clauses generally that I see would, of course, be the rent, the use, the default, and the schedules. Those kind of four things. How much would I expect to be charged to file year-end corporate fees within the first year being a loss? Unfortunately, from our perspective, we don't charge on a sliding scale. I think the question kind of hinges on, like, hey, if I made no money, do I also not have to pay any money in corporate registration fees? And the answer is no. That's one answer I can actually give you. No. What we generally charge is $175 for just a straight renewal. And then if there's a renewal, and let's say you'll have to do resolutions, that could go up to $300, because there has to be, corporate minutes and resolutions and things like that. Of course, there's disbursements and taxes on top of that, so it's not going to be, $175 to $300 all up, all in. Those disbursements and fees will have to be accounted for as well, and of course, taxes are applicable to those disbursements. So I'm not going to give you, hey, this is the range you should expect, primarily because this is recorded. And if you go to our firm and say, well, Daniel said it would be $350, why is it now $400? I could be in a bit of trouble. But that's generally what you should expect from our firm and our firm only. There may be different rates at different firms. There would be different services of those firms as well. So the answer, unfortunately, remains, it depends. And again, I'm just going to keep coming back to that kind of answer, but that's sort of what we see. What type of accountant business should I use or stay away from? Well, that depends. Certain accountants are going to specialize in certain areas. You wouldn't go to, say, MNP over Virtus Group if you were looking for a boutique offering, because MNP is a big operator, right? They have a huge office, they have a full service, whereas Virtus Group is very highly specialized in a few very distinct areas, and they're very, very good at what they do, and they cost a ton of money. What you want to do always is your own due diligence, right? You want to do as much research as possible. So that would require, phoning around, phoning Virtus Group and saying, hey, if I want to get some business planning advice on a small business with these kinds of growth margins, I'm taking in this much in revenue a year, these are my expenses. Do you think it would be, an advantageous venture for me to come and talk to you, or should I go to a smaller shop that's not going to cost as much? And I bet you they're going to tell you, hey, you know what? You can come down and we'll charge you this much, but I really don't think it's worth your time, because we're just going to charge you through the nose, and it's a huge expenditure for you. Speaking from my experience, I have turned away clients because I've told them it's just not financially feasible for you to be hiring me, because here's what it's going to cost you. And so we come to an agreement of saying, well, although I may not be able to help you, here are some publicly available resources or some other options for you that might be more affordable. And I think that's going to tell you a lot, not only about the operator that you're speaking to or the service provider you're speaking to, but it'll give you a sense of, where their priorities lie. I mean, obviously, I would like to make as much money as possible, but I wouldn't want to do it in a predatory way. And I think, as responsible business owners, you want to do that due diligence to make sure that you're going to the right type of service provider for you. And so again, I can't recommend, and as the law society rules dictate, I cannot recommend to anyone any particular service. The code of ethics requires that I don't recommend any service provider, because then it looks like I'm trying to drive business towards them. So when you see me kind of hedge from saying, oh, this particular service provider, here's where you should go because I know they're great, I can't do that. If you were to call me up, even if you were my client, I couldn't tell you that. I can tell you, these are the people operating in that sphere, and whether they do a good job or not, you can read the reviews, but that would be the only thing I would be comfortable doing. Certain lawyers might have more comfort, but as I said, I'm a 2019 call, so I try to keep very, very strict to the rules. How can I protect my intellectual property? This is a fun thing, because when I took intellectual property at university, the one line that stuck with me in the IP class is, there is no intellectual property in an idea. So it's kind of an easy saying, but it's hard to really understand. And what that means is, if you come up with an idea for a new mousetrap, and this mousetrap is a self-cleaning, 100% effective mousetrap, and you explain it to someone, that's an idea. There is no IP there. There is no intellectual property there. That's only an idea. If you write it down and you draw out the schematics and you explain how each interwoven part is to work, well, that could be IP, because you've used some knowledge or skill to reduce the idea into writing and to plan it out. That can meet the criteria of IP. It can, it might not, depending on whether or not you move to a phase of copywriting or trying to protect that. Now, more than that is probably something akin to a trademark. That might be more what this question is geared toward, is how can I protect my trademark? Because trademarks are a really interesting sphere of law. What a trademark is, it could be some insignia or some name for your business, like depending on what you're, let's say, again, I operate a cleaning business. It could be Daniel's fantastic cleaning business. It's possible that that trademark could never be registered because it's a descriptive trademark. Daniel's fantastic cleaning service. I'm qualifying what kind of cleaning service I provide, and so that could actually be rejected on the basis that it's descriptive. We actually have this happen all the time, where people come up with trademarks for their businesses and they can't be registered because either they're descriptive or they don't meet certain criteria. There's a lot of legislation around this area. The other thing is competition. There's a famous case of Barbie's Grill versus Mattel, because of course Mattel owns the toy Barbie. And so with respect to trademarks, if you don't enforce them within your sphere, you lose the ability to enforce them, which means if someone, let's say if I have Daniel's cleaning business and then someone down the road has Dan's cleaning business, if I don't sue them under trademark, as soon as I realize that they're operating in my area, I would lose the ability to sue them within a prescribed period of time. You almost have to bring the lawsuit to protect your trademark. So that's why there's so much litigation around this trademark. People like to say, that big bad businesses always sue the little guy, but in some cases they have to in order to protect their IP. So turning back now to the foundational question of trademarking, it's a very interesting area because, again, can't be descriptive and there's some other requirements you have to have. But more than that, I mean, sometimes you don't really necessarily need to protect that trademark. You know that your business is going to be small to mid-size. You're not really intending to grow anywhere beyond that. Do you need to aggressively protect that trademark, or are you okay with other businesses entering your sphere where there could potentially be some brand confusion? I mean, that's something that you want to talk to a lawyer about. But turning back to the example I gave with Barbie's Bar and Grill and Mattel, I think it was Mattel who owns Barbie, but it might be Hasbro or something. But anyway, the toy company sued the barbecue company because they said, well, there's brand confusion because there's Barbie the toy and Barbie the restaurant. And when you guys advertise on TV, people might think that we're endorsing this bar and grill because it's Barbie's Bar and Grill. So they brought an action in trademark protection. I believe what ended up happening is the judge said, look, these two things operate in completely different spheres. There is not going to be any brand confusion. I'm not going to force Barbie's Bar and Grill to change their name. That's not something that we're going to be doing. It's a US case. But you can see why they would do that because there's a potential for there to be confusion. And if they didn't bring that suit, they might have lost on another suit where it could have been Barbie's Toy Bar and Grill. And then that could be intentionally be misleading as if, the Barbie toy is endorsing the grill. Now, if you're talking about patents, which is, protecting your IP, you're talking about there's different kinds of patents and there's different ways to protect the patents, and these different patents protect for different periods of time. So when you're talking about a patent, you're talking about some innovative step. And with that, you'll see it a lot in research, like especially out of the university, they employ a patent law lawyer just to help register those patents. Now, I'm assuming without knowing that a lot of the people in this conversation today might not necessarily be dealing with patents. So I'm not going to really touch on that, but that is sort of that's part of IP. You can also talk about copyright. What copyright is the protection against reproducing work without permission. So what copyright is, it applies to written works, like a book. Let's say you write a book, you get it published, it's copywritten. It's copywritten for, I believe it's the life of the author plus some predetermined period of time. That's why a lot of those old books are on for $12 because they're no longer protected by copyright. Anyone can reproduce them without having to pay a fee. But as long as the copyright is effective, you have to pay licensing fees. And so anyone who's recently been to university will know that professors are so hesitant to reproduce sections of the textbook and hand it out because that's copyright infringement. You can't do that. And there was a huge case within Canada interpreting what's called the fair use clause. And what a fair use clause means is you can provide a portion of a work to help with interpreting that particular section without giving away too much of the work. And I can't remember off the top of my head how that case resolved, but essentially what it kind of fell down on was, we're built on a very transactional economy. You can't just provide things free of charge, and so while you can reproduce certain snippets, you can't reproduce the whole thing or a large swaths like a chapter and provide them, because again, that violates the copyright. Now you're thinking, well, I see reviews on the internet all the time that go into great detail about the work. Again, that falls under the fair use protection. If you're reviewing something or satirizing something, you're actually allowed to go in and use parts of it, but only for those specific purposes. If the purpose of what you're doing is to just make it available, you could end up attracting some liability for that. But again, that's what copyright kind of stands for. Again, if you're in a sphere where IP could potentially become an issue for you, I would highly suggest getting a lawyer involved, because you're in a very technical sphere. And what these spheres are generally are like computer programming, or where you're manufacturing or something like that, where you're making that innovative step. If you're an author, you're going to want to engage with a publishing corporation or some branch like that. Again, those services will be made available to you through those service providers, but you always want to loop in an expert in that area, because the last thing you want to do is lose whatever protection you might have by not properly pursuing those protective steps. The final question I have that was provided before the meeting today was, do I need a shareholder agreement? Well, again, it depends on if you're a corporation or not. If you're not a corporation, obviously you don't need a shareholder agreement, because what would be the point? But within a shareholder agreement, there are going to be very specific terms, such as, you know, what you're going to do if there's any internal disagreement between the shareholders, you know, the shotgun buy sell, what each role of the shareholder is, potentially, you know, whenever there's an internal dispute, of course, that's the foundational document, is a shareholder agreement. And then you can outline, you know, if there's to be a silent partner versus, you know, non-silent partners or something like that. Again, it's very important, if you are in a corporation, to have a shareholder agreement and to have it properly drafted. You can go online and you can find draft shareholder agreements. I'm sure right now, if anyone tried to Google it, you could find quite a few. You know, that, again, it may seem selfish. You don't have to use me, but you wouldn't go to a guy on the side of the road to fix your car because he says he'll do it for $1.50 versus your mechanic. You're paying someone for their expertise, and you know, their level of understanding. And if this is something that's going to affect how your business runs, your one true asset, I don't know why you wouldn't try and invest as much as possible. As I said, with limited scope retainers, you could potentially hire a lawyer only for the purpose of reviewing your draft shareholder agreement or drafting your shareholder agreement. That's all. Those are all things that you could potentially do. I mean, I'm sure there are workshops out there that help you draft very foundational shareholder agreements, and those are good for those purposes. But once your business starts growing and really making money, you can amend your shareholder agreement. Just because you have an initial shareholder agreement doesn't mean you're stuck with that shareholder agreement forever until you make a new corporation. You can amend that by agreement. So that's always good. And just like the shareholder agreement can discuss how you are to come into the shareholder agreement, can also discuss how you exit, shotgun buy sell. But it can also be where a shareholder says, you know what, I've had my fun, I'd like to sell my shares now. And there can be a discussion about how those shares are to be sold. If they first have to be offered to the other shareholders at a particular price for a particular period of time until they can be offered to the free market. Because of course, if you're in a corporation and I don't run a cleaning business, and one of my shareholders decides, guys, I've had enough, I'm done, and your shareholder agreement doesn't have anything about letting the other shareholders potentially bid on your shares first, you can have the competition come in, buy that person's shares, and now you're in bed with your direct competition. That's probably not something you really want to do. I mean, that takes it to an extreme form, but you can see where I'm going with this is that might be an eventuality you might not consider if you're drafting your own shareholder agreement. So you want to make sure that, you know, if you do draft your own, which I'm not saying don't, I'm just saying make sure you get it reviewed by someone who's got a little bit more experience in the industry. And I mean, other business providers, if you have a business mentor, that would be a great place to go. But obviously, in my opinion, the best place to go would be a lawyer who specializes in that type of area of law. So that covers, you know, do I need a shareholder agreement? And that would only be in the case of a corporation. So those were the questions that I was provided ahead of time. I've talked now for 45 straight minutes. So if anyone has any questions or comments about what I've said today, I'm happy to try and field those.
Does anyone have any questions?
That was great, Daniel. Thank you.
Not a problem.
If anybody wants to, they can
Daniel.
unmute and ask. Oh, I think there's Sherilyn. I think she's got something.
Yeah, I do. I have a question with regards to, as you were talking about the timing of moving from a sole proprietorship to a corporation. Do you also take, I mean, you just mentioned it briefly about you take into consideration the amount of revenue that you're generating. Can you clarify that a little?
The reason why I brought that up is because corporations are taxed at a different rate than individuals are. So depending on how much money you take in, it might actually be tax disadvantageous to incorporate because now you're actually losing some of that benefit. And again, this is a question for an accountant and not a lawyer, in my opinion. I'm not a tax expert. I don't practice tax law. So this comes with a huge caveat of I'm not a great source of information on this point. But if you're not making the right amount of money to move from a sole proprietorship to a corporation, it could end up costing you more in the long run. And that's why you want to loop in an accountant, because they'll advise the tax implications of making those shifts. And in my opinion, in any time that you're making any business operation change, whether it be moving from a sole proprietorship to a corporation or how you structure the shareholder agreement, you always want to involve an accountant, because of course, when CRA gets involved, they'll also look at that and they'll also see how this thing is structured. And there's been situations where people have called certain arrangements corporations, but in reality, what they are is partnerships. And the CRA can go behind that and say, well, your foundational document, that makes you a partnership. And so we're going to treat you like that. And we're going to tax you like that. So you got to be very, very careful about how those things are drafted. So that's a mix of getting the right lawyer and getting the right accountant.
And when you refer to the right accountant from a business person's perspective, are you talking about an accountant that's a good tax accountant? Are you referring to that? Are you referring to good knowledge that they don't just do personal people taxes, that they actually have lots of experience in business taxes and all those things?
Yeah, I mean, just like I said, I'm a generalist in terms of being a lawyer and I practice in all spheres. So too with accountants. They'll, specialize in personal income tax versus business income tax, right? So you want to go to a service provider who is primarily focused on business income tax. But more than that, I've seen out there where there are accountants that are geared towards startups. And so that's where their area of expertise is, because they'll know about grants and tax forgiveness and certain things like that. And I mean, especially for an organization like Sage, there might be certain grants or exceptions that might be available to certain types of businesses that you might generate versus others. So you want to make sure you're educated about those grants and bursaries.
I'm going to ask you another question. This goes back to your intellectual property or copyright. So if you've invented or created this idea of a program that you deliver as a workshop, and it is very unique as far as you're concerned, you haven't seen it used anywhere else. Is it worth that person's while to try and protect it under like intellectual property or under copyright or something, or is it not? I guess that would be my question.
I mean, it depends. If you're dealing with a situation where you have a service like an in-service that's very easily reproduced, you might want to look into whether or not you can copyright that particular presentation in the way it's delivered, because there might be certain modalities and certain slides you use that aren't apparent in everyone else's. But of course, you want to contact an IP lawyer first to make sure that what you're delivering is actually copyrightable, because it could be that it just doesn't have the indicia of something that can be copyrighted. And then what you're trying to do is copyright something that just isn't something that meets the classification that can be protected. So again, that comes down to meeting with a lawyer that operates in the IP sphere and making sure that you have the proper protection. I can tell you, again, IP is not an area that I practice in. It's not something that I have a lot of knowledge of, but it's something that I can watch out for and say, well, this might be something that's copyrightable. In terms of a presentation or presentations, that could potentially attract copyright. You might want to talk to the lawyer. But as I said, there's no IP in an idea. So if you just have an idea for this type of deliverable, that's probably not worthy of copyright. But if you've actually sat down, created the slides, have a deliverable product, like let's say a recording, that could probably be copywritten, because that could be reproduced and distributed.
Okay, I'm going to throw another one at you since we've got you here. So we have a client in Indigenous Business Development Services, and he has actually created, it's a teaching tool. It could also be a game. It also teaches culture. and all of those things. But it does involve a set of cards.
Yeah.
Okay, like playing cards.
Yeah.
Okay. Now, I don't know how easy it would be to duplicate it, but should he be looking into protecting his intellectual property?
I think so.
Yes.
Yeah,
Okay.
you should probably get in contact with someone in the IP sphere and have a conversation about exactly what it is that he's produced. And I mean, it certainly sounds to me the game in and of itself, that's probably worthy of copyright, not to mention the teaching tool and everything else.
Right.
Yeah, you probably want to talk to someone about potentially copywriting that.
Okay.
But it's all, again, it's all very highly contextual and fact specific. So if at the end of the day, it doesn't meet the criteria, it is what it is, but at least you've done that due diligence.
Fair enough. No, that's good. Okay, one more question, but you guys can cut me off anytime you want to. We have another client in the IBDS that is looking at getting into a joint venture
Mm,
with a much larger company.
Yeah.
Now the larger company has done this kind of setup numerous times, not so much in the province of Saskatchewan, but numerous times.
Yeah.
And so, I mean, they're preparing the joint venture contract. Now, our suggestion to him is to go and see a lawyer once you have a copy of the contract they want you to sign, to make sure that you clearly understand what you're getting into.
Yeah.
And of course, they're not saying that. They're not telling him to go and do that. And so, in your opinion, I mean, joint ventures are tricky.
very much so.
And I could see people getting hurt if they didn't understand what they were really getting into.
Absolutely. It would be very much my advice as soon as he gets a copy of the joint venture agreement, which is what they should be sending him. Then that is something he absolutely should be taking to a lawyer, because that will set out the entire relationship as between him and the parent company. Because as part of the joint venture, there's going to be, necessarily speaking, there has to be some consideration in order for the joint venture to be effective. So the question becomes, okay, what consideration am I giving the parent company, and what consideration is the parent company giving me, right? What benefit am I getting from this? And if it's not balanced, or in worst case scenario, if it's tilted toward the parent company, then you want to make sure that, oh, well, we got to renegotiate these terms because those are not favorable terms. The other thing is, you don't want to be bound by a partnership or a joint venture agreement that necessarily is predatory, right? So you want to make sure that you're not, pitching your way into a situation that could effectively ruin your business.
Yes.
Right. As you say, they're not telling him to see a lawyer, but at the same time, they're not telling him to not see a lawyer, I'm assuming. Or if they are telling him to not see a lawyer, that should raise some red flags. Because, if someone says to you, don't see a lawyer, you don't need a lawyer, just sign it with us. Trust me, I'm trustworthy. No.
No, I don't think they're saying either, like at this point. But just because joint ventures can be that's a very tricky business format. And, but I also too, I mean, he's saying, well, what am I paying out? What do I want to go and pay all these legal fees?
Yeah.
And so, but it is, I mean, it's far different from being a corporation.
Yes, it is. Yeah.
These are two corporations that are going to join together for a specific purpose.
But I think you're asking a good question in that, if I have a joint venture agreement from a big corporation that's done this multiple times and I know what I'm getting into, why would I waste my time and money getting a lawyer to tell me that which I already know? And I kept saying the words due diligence during today's presentation, and that's exactly what it is. You're doing your due diligence by giving the joint venture agreement to a lawyer to tell you, hey, you know what, there is nothing to worry about. But in the same breath, if there is something to worry about, wouldn't you want to know about it before you sign the joint venture agreement, not after it becomes a problem?
Yeah.
It's the difference between reactive and preventative. And you don't want to be reactive, because when it gets reactive in terms of the law, that's when your bill is $10,000, $15,000, $20,000. When it's preventative, that's a $5,000 bill. And that's sort of how I position things for businesses. Is it's much better to be proactive and over cautious than be reactive and try and fix an already broken scenario.
Okay, thank you. That's all my questions. Anybody else has?
That was some really good stuff. Those were very good questions. Does anybody else have anything for Daniel?
This is the one time you get to talk free with a lawyer.
He's given us some really good things to think about and
Yeah.
you know, and
Kate
lots of
Morris
things that,
Kate
Oh,
has
does
taken
Kate-
her, she's put her.
hi, Kate.
Hi there.
Hi.
Boy, I look different than that profile picture, hey? Don't we all? Thank you so much for offering this. I do apologize. I arrived late. I was actually on another finance webinar. But I'll just speak from a personal experience that I've had. And I'm actually I'm writing a book. It's knowledge-based book, right? So, but it does have some Indigenous content, like a lot of Indigenous content to it. Now, I had to walk away from a book deal offering, because they insisted on owning the intellectual property to the book that I was writing. And I was very clear and explicit that it's not something that can be licensed to be owned. It's knowledge sharing, so it can't be owned by one entity. And very recently, I had another client that I had to walk away from because they wanted me to write academic content. But again, they wanted me to sign off an intellectual property agreement that I said I'm just not comfortable with anybody having ownership. So those were two big opportunities that I just morally, ethically felt I couldn't. So I'm not sure. And one of them tried to kind of frame it like, oh, no, this is just to protect your interests. And I wasn't sure on that. So I'm not sure how I can proceed in terms of self-publishing things so that I don't have to give my intellectual property and cultural traditional teachings away to others. So if there's, and I arrived late, so I might have missed the conversation on intellectual, well, I definitely missed the conversation on intellectual property. So I'm hoping you could kind of help.
Yeah, that's a pretty complicated question in terms of, I think it comes down to cultural competence. If you're talking about, traditional and cultural teachings, but your traditional and cultural teachings dictate that they're supposed to be shared, that they can't be owned by one entity, and you don't feel comfortable because that runs against your cultural teachings and requirements. I think that requires that you need to loop in someone who's got both a cultural background and a law background who can speak that language. And then that honestly isn't me. I don't know enough about that culture aspect to have an intelligent conversation. And I think what it may come down to is planning with that person who has both the knowledge component and the cultural component to be creative about who could potentially own that copyright, whether it's say a band, if it's your band or whatever, who could potentially own that, or setting up some other situation where a third party might hold it, not you, but wherever that knowledge comes from, to pay respect to that. But again, and I apologize if I'm missing the point here, but it's very hard when you mix in cultural sensitivity, because again, that will very much dictate on an ethical basis how you want to do things. Because you're talking to someone, especially me, I would put your interest ahead of anybody else's, right? That's sort of what we're taught in law school, is to advocate for your client above all else. And so that might be why there was that, you missed each other there, because what your lawyer might have been trying to do, or your business developer or whatever, might have been trying to put you in the most financially profitable position possible. But in reality, that wasn't your interest, right? Your interest was paying respect to your culture and being true to your culture. And so that's why there was that language gap. So in an answer to your question, what should I do if I want to be able to produce works but not be caught by copyright conventions? The answer might be to get in touch with appropriate First Nations councils. I know there's probably national councils that could help in addressing this particular issue, because I want to say I'm confident, I'm not sure, that this, as I understand it, the First Nations culture is very storytelling based and live. Like it's not written traditionally, as I understand it. And so that's probably something you need to address with whoever is helping you with those copyright problems. So, there's a very wordy way of saying, I'm not really sure how to help you with that. I think you need to contact someone within who specializes in First Nations law. And that's a developing area of law right now. So unfortunately, I'm sorry that I can't provide more information than that, because of course that's very dependent. It's a very unique circumstance you find yourself in, because you're dealing with a westernized concept bringing in traditional views.
Thank you. And going forward a little bit, there is, I listened to what Cheryl was saying about one of their clients that produced something. I actually created a teaching context as well. Some of it is traditional teachings, but it's still my concept that I've tapped into some of the traditional teachings and married it with modern teaching. So that part probably needs to have an IP or some kind of a trademark or registry, because that is my unique concept, but it's not licensing the traditional concept of it. So it is kind of a unique product, but I'm,
It's you I was talking about, Kate.
Oh, thank you. Thank you for that. So it's really very, very fine line there. That am I there or am I here? But I'm very cautious with how I put it out there, but now I've been invited to present at national events. So everyone's going to get a taste of it. Someone's going to run with it, but it was my original concept that I created several years ago, and it really resonates with my audience. And part of it is a traditional cultural, drawing on my traditional cultural teachings that I've been exposed to.
Yeah. And so, I mean, of course, the traditional cultural teachings, those wouldn't be copyrightable, because of course those are in the past. That's not your own knowledge, but the way you fused it together with your particular delivery system, that could be copyrighted potentially. And again, that's part of the due diligence of meeting with someone who can both speak the language and understand the cultural concepts, right? And that's why you're in such a unique sphere, because you need to have someone who can understand those things. And I can very confidently say that's not going to be me. I don't have that background. But there are people that do practice Indigenous law in Saskatchewan who could probably, at least with respect to speaking the language, help you. And then where this could be advantageous is you could loop in that lawyer with the IP lawyer, so the two lawyers could have a conversation about both protecting the IP, but also being sensitive to the cultural requirements that you operate under.
Awesome.
If she does go ahead and copyright it, my last question for you, Daniel, if she does go ahead and copyright it, I mean, then she actually has to defend it if people should start to use any part of it. Is that correct?
Yeah, and so therein come, as they say, therein lies the rub. You have to prove that it's your copywritten material that's being used by somebody else to derive a benefit, right?
Right.
And a great example is like trespass. Just using an example, so trespassing is something you can sue somebody on without any proof of damages. So if I walk across your front lawn, you can sue me. Anyone can sue anybody, but you have to prove what damages you suffered. So if you say, well, Daniel walked across Jessica's front lawn, and for that reason, I'm going to sue him for $50,000. Well, that doesn't make any sense, because what ground could you possibly establish that there's damages in the amount of $50,000? So what this would carry over to in Kate's situation is, if she can prove that someone's using her concepts, she has to prove that, number one, that person's using her concepts, but number two, what are the damages, right? What benefit is this other person deriving, or what benefit is Kate losing?
Yeah.
And so here I want to be very, very careful. We're drifting from creating a business into civil litigation. And civil litigation is so fact dependent. I don't even want to go anywhere near that today.
Okay, good enough.
Well, we're sensitive to your time, Daniel, so I want to let you go, but I just want to say thank you. It's been super great having you. And it's
Not a
been
problem.
very
Yes.
Thank you for the
informative.
invitation.
Thank you so much.
Thanks, Daniel.
Bye-bye.
Bye.
Bye-bye.
Thanks, Sherilyn, for sharing that, for speaking, like bringing it up.